Peace and blessings, everyone. Peace and blessings. Peace and blessings. Peace and blessings. Hi, everyone. This is Tamara T. Bush coming to you with another lesson on consumer clarity. So I, during the month of March, is providing clarity on consumer law, right? In an easy to understand way, in a way that is easy to understand, so you all can take this information and use it and apply it to your specific situation. So go ahead and share out this broadcast. I want to go ahead and cover a topic tonight that we should be focused on before we start focusing on going after companies for violations. The question is, here's the question, you ready? Does your consumer report look the way you want it to look? Before you can even think about going after one company for violations, before you do your administrative process, before you do anything at all, have you been able to properly go in and structure your consumer report for it to look the way that you want it to look, so that you can go ahead and get the things that you need? That is the question tonight. That's the question. Because some of you all have been asking me, hey, what do I do? Do I submit this paperwork? Do I do this? Do I do that? I got to back it up a little bit. I do have to back it up. I got to back it up because, again, does your consumer report look the way that you want it to look? Meaning, are all your inquiries gone? Are all your charge-offs gone? Are all your collections gone? Do you have low utilization? Right? Have you cleaned up all of your personal information, your name, your address, your employer, your telephone number? Have you cleaned those things out? Can you submit your letters in a way that uses consumer law to your benefit, where you can get the consumer reporting agencies to do what you want them to do without question? Because part of the problem is that if we can at least get them to do what we need them to do, how are you going to fight them in court, right, on the law, if you're not able to enforce the law with the CRAs first? So what will your argument be if you can't get them to do what you need them to do before you even get to court or to arbitration, right? Whatever that situation is. So go ahead and share out this broadcast. I am in the process of doing that now. Just want to make sure that everyone is seeing this. Everyone is hearing me. Put a 1 in the chat if you can hear me. Put a 2 in the chat if you can see me. And don't forget to drop your city and state in the comment section so that I know exactly where you are tuning in from. Yep, definitely need to know where you're tuning in from. All right, and I think we are good to go. All right, so we're good to go. So yeah, so back to the original question. Out of all the things that we're doing, and I know that the topic of consumer law is piquing a lot of you all's interest, right? You're curious and you want to get to that remedy really, really fast. I'm here to tell you that this is not a microwave process. There is no overnight fix for your credit. There is no overnight fix. There is no overnight process for you going after these companies. You have got to study and you have got to test. You have to test this information, right? And you have to take it and tailor it specifically to your situation. There is no template, because you are literally telling your story. You are telling your story. I need you all to let me know if you can hear me. Okay, just wanted to test it out real quick just to make sure that you all can hear me, make sure that there's no technical difficulties. But yeah, so does your consumer report look the way you want it to look? That's the question, right? Are you at that 750 FICO score yet? Are you even at a 700 FICO score yet? If the answer is no, there's some work that needs to be done. Because let me tell you, when you begin to go after these companies, you have some companies that are going to close your account. They're going to discriminate against you for exercising your rights in good faith as a consumer. Are you ready for that? Are you ready to have your credit cards closed? Of course, there's a way to get them reopened. But do you have a contingency plan when they begin to close your revolving accounts? Because let me tell you, it's going to happen, but you have to know how to defend yourself and you have to know how to fight back. So, you know, it sounds good on paper. It sounds good when you hear people say, yeah, you can go after these companies, right? Of course you can. But what they're not telling you is what's going to happen when you begin to go after them, because they're not going to roll over and say, oh, I'm so sorry, we violated you, we owe you $1,000. It's not going to be that easy. It's just not. Ideally, it should be that easy, right? But it is not that easy. These companies, these are corporate criminals. They are out here to lie, steal, cheat, kill, and destroy. That's the enemy. And the enemy will never admit that they are wrong unless you are able to back them up against the wall with the law that backs you as a federally protected consumer, period, point blank, right? There is no way that you can do this without having some form of adverse action performed against you, because they're going to buck back at you. They are going to test your gangster. They're going to call your bluff. They're going to do all of these things. But unless you know the law like the back of your hand, you are going to lose. You're going to lose. And so the way that we get practice, right? The way that we get our practice is by going after the CRAs. The CRAs are some of the most easiest companies to get money out of, because they literally violate you every day. You don't have to worry about them closing anything. There's no account to close. Get your practice with the consumer reporting agencies, TransUnion, Equifax, Experian. Get your practice with the consumer reporting agencies. So the statement is leading me to the topic that I'm going to cover tonight, right? We're going back to the FCRA, the Fair Credit Reporting Act, so that we can talk about what should and should not be in a consumer report. And it leads back to your structure. So if you know that something is not supposed to be included on your consumer report and you have the tools to get it removed, then you are equipped to do the work, right? I want you to be equipped. I don't want you to be blindsided by a credit card company that because you had one little law that you wanted to try out and they came back and they closed your account and now you don't have access to your available limit on your credit card, right? This is important. This is very important. So let me go ahead and share my screen. And we're just going to cover one law today. Just one nail. Some of y'all know that joke. Just one nail. Okay, so I am in 15 USC 1681A. This is the Fair Credit Reporting Act. And remember, I'm always going to the Legal Information Institute. I am on the Cornell Law website. You can literally Google 15 USC 1681A, and it will bring you to this site, probably first before any other website. So this is basically all of the definitions of the FCRA, right? It's giving all these great definitions. But the one part that I want to focus on is the exclusion section of the FCRA, because it is literally giving you what it should not have. So then if Congress is telling you what it does not include, but you have companies that are reporting things that they're saying as per their company policy they should include, then you have to ask your question, when does company policy ever trump federal law? It's a simple question that has a simple answer. It doesn't. It never does, right? Okay. Exclusions, except as provided in paragraph 3, the term consumer report does not include. Okay, so let's look at the definition of consumer report. The term consumer report means any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, which is used or expected to be used or collected in whole or in part for the purpose of serving as a factor in establishing the consumer's eligibility for credit or insurance, to be used for personal, family, or household purposes or employment purposes, right? That's the definition of a consumer report. Okay. All right. So what does it not include? It says it does not include, this is what is not supposed to be in there. All right, report containing information solely as to the transactions or experiences between the consumer. Okay, who's a consumer? Means an individual. That's you, that is me. And the person, who's the person? An individual, partnership, corporation, trust, estate, cooperative, association, government. You get the gist. Okay. Any person making the report. Okay, so let's break that down for a second. Let's break it down, right? Let's break it down. Okay. So it says transaction experience. I like this section right here. Transactions or experiences. Okay, well, what's a transaction? A transaction is exactly what it is. It's a transaction between you and that company. The person making the report is that company because they define the person as a corporation, right? Okay, but what is a transaction though? When you go to apply for a loan, that's a transaction. If that company is reporting a 30-day late, isn't that a transaction? Isn't that an experience? If that company is reporting high utilization, isn't that an experience? If you have a charge off on your credit report, isn't that an experience or a transaction? If you have a collection account on your consumer report, isn't that an experience or a transaction? I'm trying to get you all to see how this is broken down. So Congress is virtually telling you that none of this information, none of it should be reported on your consumer report. So the question is why do we continuously allow these companies to report items that we don't want reported? This section alone right here empowers you and gives you the tools that you need to get everything removed off of your consumer report that you don't want to be there. Right? Does not include communication of that information among persons related by common ownership or affiliated by corporate control. Right? It's literally telling you what is not supposed to be there. So I ask you the question again, does your consumer report look the way you want it to look? Do you have all of your data points? Do you have all of your data points, right? This is something that we have to focus on because we are literally out here grasping at straws. And we have to switch our mindset, right? I attended a seminar over the weekend in Oklahoma. One of the speakers was unable to make it because they were hospitalized. So the host of the seminar asked me at the last minute to step up and speak in their place. And it was totally unexpected, right? But this is what I understand. When you know what you know, you don't have to be prepared because everything is in your mind, everything is in your brain. You should be able to talk about your area of expertise with no preparation. And so I got up there and I spoke about this law. I went over this information, and one of the ladies asked me after the seminar, she said, where were you reading from? She said, were you reading from an article? I said, no, it's not an article. This is the Fair Credit Reporting Act. This is the FCRA. This is actually the law. I was reading from the law. She's like, huh, I never knew that. Some of us don't know. And it seems unreal when someone comes along to break this information down in layman's terms. It almost seems like it's too good to be true, like it's not real. And I had the same screen up, Cornell Law Legal Information Institute, but a lot of people don't know that those laws exist. You hear FCRA, but you don't necessarily equate it to, oh, is this something that I need to know? Is it something that I need to read? How does this apply to me? Most of us don't equate that to how that applies to us, right? So I told her, I said, you can Google it. Just Google it. 15 USC 1681A. And it will literally give you the definition of what I just explained at the seminar, right? So the law is literally telling you, it's literally telling you what should not be on a consumer report. So how many of you were able to go and pull your consumer report off of Experian, Equifax, and TransUnion last week? That was the homework that I gave you. Put a 4 in the chat if you were able to get that done. And it's okay if you weren't able to get that done, because remember, you have the ability to go and pull your consumer report once every 7 days. That was allotted to you by Donald Trump when they wrote the CARES Act, right, due to COVID-19. Right? So if you didn't get a chance to pull it last week, don't beat yourself up, don't fret, go and pull it this week. Even if you pulled it last week, go ahead and pull it again. Pull it again. You should be watching your consumer report just like you watch your money in your bank account every day. It's that important. Like, it is literally that important, right? You know, cannot make this stuff up. So why is it telling you? Why is it telling you that this information should not be on your consumer report? Right? Why? Because now this is going back, we're still in the FCRA, 15 USC 1681. I just went back to the congressional findings page. We're still in the FCRA, but this is something that we have to pay attention to, right? There's a need to ensure that consumer reporting agencies exercise their grave responsibility with fairness, impartiality, and respect for the consumer's right to privacy. You had a right to privacy and you didn't even know. This is why Congress is telling you that this stuff should not be on your consumer report, because you didn't give them permission to put it there in the first place. They have to respect your right to privacy. And when you write your letters, you put that in there. You must respect my right to privacy. I have a right to privacy. That should be in every single letter that you write to the consumer reporting agencies, every single letter, before you even mention any law. You put in there that you know that you have a right to privacy and they are violating your right to privacy as a federally protected consumer. Every single letter that you write should have that in there. And you tell them that you know that they have a grave responsibility, right? And remember that Congress defines them as an elaborate mechanism. They assumed a vital role. What does it say? They have assumed a vital role. I'm literally telling you how to construct your letters. Equifax, I understand that you have assumed a vital role in assimilating information on me as a federally protected consumer. You're literally putting this in your letter. And you are letting them know that they are impeding the banking system because they are not vested in ensuring that your credit reports, your consumer reports, are fair and accurate. Right? They are impairing the efficiency of the banking system. You have lost confidence in the system because the system is not working for you, because these companies are not vested in ensuring accurate consumer reporting. Right? They have undermined public confidence, which is essential to the continued functioning of the banking system. How can you continue to take advantage of a system that no longer benefits you? They are constantly violating your right to privacy. They have to have systems in place to ensure the accurate reporting of information to your consumer report. And again, if you did not give them explicit written permission to report the information, then they're violating you. Because what does it say? They have to adopt reasonable procedures for meeting the needs of commerce for the consumer credit, personal insurance, and other information in a manner which is fair and equitable. Has the system been giving you equitable relief when you notify them that there's an error on your consumer report, or do they just come back and let you know that it's been verified? How are they verifying this information? How? How are they verifying this information? Like, seriously. I mean, how are they verifying this information? So it's time for us to fight back. It is literally time for us to fight back. We have to sit down, construct our letters in a way that is applicable to our personal situation to let these companies know that they are willfully non-compliant, that they are violating your right to privacy, they're violating your rights as a federally protected consumer, that they have a duty to ensure the accuracy of your consumer report, right? That's what they're supposed to do. That is what they are supposed to do. What does it say? Whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual about whom the report relates. Does that make sense? A consumer reporting agency may not prohibit a user of a consumer report furnished by the agency on a consumer from disclosing the contents of the report to the consumer if adverse action against the consumer has been taken by the user based in whole or part on the report. We have to get in here and read these laws. We have to really get in here and read and study these laws. So when you take this information, the exclusions portion of this law, because you can literally go in and begin to dispute items that you know is not supposed to be there because you never gave them permission. So then you circle back to the 4-day block and remove method, right? 4-day block and remove. Because again, remember, I will always say this, I will say this time and time again, no consent equals identity theft. So if you did not give them explicit written permission to report, that's identity theft because they never had the permission to use your information. You circle back to 1681C2 and run the process. Here's the process right here. That's the process. You do your identity theft report, right? And we said before, that is identitytheft.gov, right? Oh, it's giving my login information, but identitytheft.gov. Guys, this is not rocket science. This is not rocket science, and don't overcomplicate things. And you definitely want to make sure that you handwrite your letters. Because these companies, let me tell you, when you send in your dispute letters to these consumer reporting agencies, there is no human that's reading your letter. They run it through a system called eOscar. They take your letters, they remove it from an envelope, and they feed it into a machine. This allows them to compile data about the different dispute letters that they're receiving. And so what they can do is they can match up letters from this person and that person, and they can find similarities in an instant of letters that are coming from different people. This is how they know that you're working with the credit repair agency. They keep a copy of every single letter that's ever been sent to them. And so when your responses are coming out to you, these are not people sitting at a desk typing up these responses. These are machines spitting out an automated generated response to your letter. So we have to get very crafty in how we send in our dispute letters. And one of the ways to do that is to handwrite your letter, because a machine cannot read your handwriting. You want this letter to end up on the desk of a real, live, living, breathing person. And you let them know in your letter that you do not consent to e-Oscar verification. You do not consent, right? You do not consent. You have to spell out the specifics and let these people know that you do not consent. Because what happens is when you go in and you submit a dispute with the consumer reporting agencies, they will almost always come back and state that the debt has been verified. Almost every time. And I know that it's frustrating to people because they're like, well, how are they verifying the debt if I know that I don't owe the debt? It's an automated generated response by a computer, by a machine. Right? It's being done by a machine. Right? And so anytime that they're validating the debt, it's unlawful for them to use the information submitted by the furnisher of that account. They are supposed to conduct personal interviews with family, neighbors, loved ones. They're not supposed to use the information submitted to them by the furnisher to validate that debt. That's against the law. It's against the law. Let me show you. Right, it's against the law. And it is in this section right here. Now this is 15 USC 1692. This is the FDCPA. Right? This is the FDCPA. So it says if a consumer notifies the debt collector in writing within 30-day period, right, that the consumer requests the name and address of the original creditor, the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or a copy of judgment, the name and address of the original creditor, and a copy of such verification of debt. Right, so this is basically what the consumer reporting agencies are supposed to do. They usually, well, they're supposed to conduct an independent investigation outside of the investigation that will be completed by the actual debt collector. So a consumer reporting agency is not supposed to rely on the information provided by the furnisher of that item. They have to conduct an independent investigation of the information that's being reported. So they're supposed to conduct personal interviews. They're supposed to notify you who they're going to contact to conduct these interviews, just like the FBI conducts interviews and the police conducts interviews when they're investigating a case. The consumer reporting agencies are supposed to do the same thing, but they never do. They never do. They never do. So we just have to read and we just have to know exactly what it is that we're supposed to do. So when we send out our letters to these consumer reporting agencies and these debt collectors, we should already have a response written and ready to go, because we already know that they're going to come back and state that the debt is verified. We already know that the company is going to come back and state that the debt has been verified, and they're not going to send you anything but a bank statement or a history of account or a history of payments, and that's not evidence that you owe a debt, because if you refer back to 18 USC 8, you know that all obligations, public and private, belong to that of the United States. So what exactly are they proving that they owe? What are they proving that they owe? Tell me. I sure would like to know. What are they proving that they owe? Yeah, so it's deep out here, y'all. It's so deep. But anyway, study, study, study. I cannot reiterate that enough. Study, study, study. 15 USC 1681, 15 USC 1692, and 15 USC 1601. That is the FCRA, the Fair Credit Reporting Act. That is the FDCPA, the Fair Debt Collection Practices Act, and that is Truth in Lending, TILA. We just have to study. I know it seems like a lot, but you all can do this. I am praying for you all to get this information, take it and use it to your advantage, because it is really literally time for us to fight back. It's time for us to fight back. So I want you all to drop your comments on this video if you're watching live, or if you come back to watch the replay. Let me know how you've been able to use this information to your benefit, and if you at least have been able to go and get your consumer reports pulled, right? Every single week, annualcreditreport.com. Watch your consumer reports just like you watch your bank account, right? And let's go. So again, this is Tamara T. Bush coming to you with more clarity on consumer law. Let me know if you have any questions. Shoot me a message, leave a comment down at the bottom of this video. And I wish you all much success. We only have 2 more days left in the month of August. We have the 30th and the 31st. After that, I'm done. We were only doing this during the month of August. So I'm not done, but I'm done with, with Monday through Friday, right? So we only got 2 more days left. So I would love to have the last 2 days of March be a Q&A, because I know that you all have questions, right? I would love for it to be a live Q&A. And I think for tomorrow and the day after tomorrow, Thursday, we're going to take this conversation over to YouTube. We'll take this over to our YouTube channel. Yeah, so if you want to participate in the live Q&A, I will be going live. Actually, let's do it on Thursday. Let's do it on Thursday. I'll be going live on Thursday with the Q&A. That's going to be the last day of March. That's the last day of the month. It'll be on Thursday, March 31st. We're going to do a live Q&A over on my YouTube channel, which is at Tamara T. Bush. So I hope to see you all there. Definitely bring your questions. Bring your questions. If you have letters that you all would like for me to look at, shoot me an email at info@tamaratbush.com. That's TAMRA, the letter T, the letter B as in boy, USH.com. All right. Come on, y'all. Let's get to doing this work. We definitely got to study. I want to hear some success stories. Come with your questions on Thursday. I hope to see you all there. You all have a great evening. Peace and blessings.